Welcome back to the Law and Crime Network. I'm Heather Hansen, and we are in a short break in the Donald Smith case after watching a lot of video and hearing a little bit of testimony that I definitely wanted to go over. And fortunately, I have a guest here to go over it with, and it's our own Aaron Keller. Aaron, thank you for joining me while we talk about this a little bit.
It's always nice to talk to you and have other people listen to the conversation because normally this is going on and it's just one testimony.
We just go over all of this stuff on our own. Now, this case, we've been talking with everyone here at the Law and Crime Network, our technical team, and everyone, I think, agrees that this is probably the most disturbing case we've ever covered. Do you agree with that?
I would say so, yes. I mean, we're taking the accusations as true at face value, and of course, this state has the burden here, and it's important to set that out. But look, the evidence in this case is so strong that I'm going to be shocked if the defense finds a way to convince this jury not to go for a guilty verdict across the board. We've got the surveillance footage. We've got the mother's testimony. We have the Amber Alert. Right after the Amber Alert, we have a tipster saying, hey, wait a minute, I think that van is back in this like sketchy, marshy swamp near this church. Why is it back there? The tipster calls police. They track the van down the road. They pull the van over. It's got the guy in it. The same guy wearing the same clothes as the surveillance footage. It's the guy that the mother says, yes, that's the guy. The clothes are wet, they're dirty, and then they find this poor girl's body in a creek in this marshy area. So it's like the puzzle just comes together.
Absolutely. And you've done a lot of reading and a lot of research on some of the pretrial documents in this case. And I was asking you because earlier today we had Jonna Spilbauer on here with me, and we were talking about this opening that the defense attorney gave where she talked about, I plan to cross-examine the mother, Rain Periwinkle, and I'm going to cross-examine the mother. And we've always talked about how lawyers can't make promises they're not going to keep. And then within an hour, she gets up to cross-examine the mother, and her client, Donald Smith, says, don't do it. Why, first of all, I have to ask you, could you find anything in what you reviewed that would sort of help us to figure out why they were trying to blame the mother in this situation where clearly the mother didn't abuse her, the mother didn't rape her, and the mother didn't murder her? How does that help with the defense?
I didn't see anything. And of course, look, these pretrial motions are hundreds and hundreds and hundreds of pages long. But from what I can see, they're blaming the press. Okay, shouldn't be covering this. You're destroying his right to a fair trial. And I'm very tuned into that because I was a street reporter who covered these cases, and I've seen strange prosecution ethics before, or a lack of prosecution ethics before. But look, that's one thing, blaming the press, other parts of this, blaming the investigators for putting a recording device in between the defendant's jail cell and another inmate's jail cell.
Right.
Okay, and we saw some discussion of that in the opening statements as well. So it's a lot of procedural stuff like, well, this shouldn't have gone on. But no real clear defense. The only thing I can think that they're doing with the mother is trying to say that the story sounds so crazy that this mother should have had alarm bells, flashing lights going off in her head, and she should have known that this was a situation that was bad, or that it's so crazy that we're not supposed to believe the mother? I mean, is that where the defense is going?
It's crazy because I think that a lot of viewers are probably looking at this and saying this situation was crazy. The mother should have known better. Why is she letting this man anywhere near her child? Why are they getting into a van with this man? All of those things. But I just don't get how that creates a defense here. And clearly the defendant himself must have changed his mind on that because he said, don't question her.
Oh, I mean, this turned into a huge headache for the defense attorney already today within hours. The only thing I can think of is they're trying to say that either don't believe the mother or that the whole story, that she's adding details in it to try to get a conviction, and that the real story isn't this catastrophic, I guess, and that's somehow going to mitigate a possible death sentence.
See, I was thinking that perhaps she was going to try to say that between the time that they left the parking lot, because those two last witnesses, and I want to talk about them in a little bit more detail, but not only, you just gave us a really great timeline of every step of the way, but not only do we have the video of Donald Smith and Cherish Periwinkle walking out of that Walmart and into the parking lot, but we have this couple that we just heard from who saw them in the parking lot, and Donald Smith pulled up and said, we're going to get cheeseburgers, which everyone thought was very strange. So that's even a step further. But somehow the defense maybe was going to argue that in between that time and the time that the body was discovered, someone else came along and stole her from Donald Smith. I think that's the only thing they could possibly do here.
The only thing I can think they're trying to do, and Kathy Russin, our senior trial producer, just pointed this out to me. She said, look, the defense isn't even trying to go for not guilty. They're just trying to.
Of course.
They're just trying to. She said they made it clear in openings that they were just here because of the death penalty, and that's the issue. And a lot of the pretrial wrangling had to do with an issue we've talked about in a number of other cases we've covered here, and that's that Florida had to retool all of its death penalty procedures because there was a constitutional challenge, and that's why this case has taken years and years and years to get to trial. So their tactic here must be to try to use some of this to mitigate what was going on, as if other people should have.
But that's
I don't understand. I don't get it either, but that's the only thing I can think of that they might be trying to go for.
I brought this up with Jonna this morning, and if this is actually true, it would be really strategic and very smart, maybe. But I was saying that maybe the defendant saying, no, don't cross-examine the mother, don't make it any worse for her than it has to be. Maybe they're hoping to ingratiate themselves, meaning him, Donald Smith, to one of the jurors enough that that one juror, he or she, and I think this jury is a majority of females, actually decides that no, I can put him away for life, but I can't give him the death penalty. We're seeing on the screen as we talk some shots of the defense attorney there with her client, and it's interesting to me as a female defense attorney defending someone like this. It reminds me of the Nassar case where we saw that female defense attorney, I think her name is Shannon Smith, who's defended Nassar. And I do think it's a little bit interesting when you've got a judge who's a female, a prosecutor who's a female, the defense attorney who's a female, and primarily females on this jury. Do you think that that's going to impact the verdict in any way, Aaron?
I would hope not, frankly. I mean, the better angels of our nature would tell us that regardless of who's sitting on the jury, that they're going to take their oath seriously and apply the law. I mean, I'm a stereotypical white male with premature gray hair, and I would look at this thing and say, if the accusations are true as alleged, okay, and they're playing out just the way we suspected, I would find this just as disgusting as I think that you would.
Right.
So I mean, I know that we all bring our backgrounds and our notions into things, but I would hope that in the United States justice system that people take that oath seriously and they hone in on what the conduct is, does it match the letter of the law, and that transcends gender, race, ethnicity, upbringing. It transcends, at least in theory, socioeconomic status, all of that.
Yeah, I mean, I think that's true, but I think that there's also a reason that we have jury selection and that we pick certain jurors, and the idea that these women are some of them mothers, right? Maybe they'd be harder on this mother, and that's why the defense attorneys are arguing that so strongly. The whole thing is just completely bizarre to me. I would love the opportunity to speak to some of the players after this case as to what was going on in that opening and what happened with Donald Smith sort of taking away the opportunity from that defense attorney to do what she had planned to do. I mean, gosh, can you imagine you're getting ready to cross-examine your key witness that you've just promised the jury that you're going to do everything you can to cross-examine, and your client tells you, no, don't do it? It certainly changes your day.
I mean, I would hate to be in that situation, and we watch defense strategies backfire from time to time here, and this is one of these things where if you make a promise to a jury, then you almost have to deliver it. It's otherwise it turns into bait and switch. I think the jury is going to judge the defendant more harshly because of that. I mean, if anything, she could have done a soft cross. Just said, well, ma'am, you've gotten up here and you've taken an oath to tell the truth. Yes. I mean, you've done these before, I'm sure. And you take that oath seriously. Yes. And nothing else that you need to add to your story. No, thank you. And then just walk away from it. And then you can at least argue, say, hey, look, I mean,
her client wouldn't let her. I mean, it's just, this whole thing is just utterly, utterly bizarre. And it's really, I mean, it's an interesting issue because we would not be here but for the death penalty. He's fighting, as you stated, for his life. So this case would not be trying. I mean, I think he would have accepted a plea deal had it not included death. But the other thing that we talked about a little bit this morning that I think is interesting here and terrible is that this man has been arrested and as a registered sex offender, had just gotten out of the county jail 3 weeks before this kidnapping and this case with Cherish Periwinkle. And yet the jury under our system doesn't get to know any of that, chances are. Do you think that there's any chance that gets in, Aaron? Any of that pass?
I mean, if it's proof of a common scheme or plan, then maybe. And I haven't gotten into all the motions in limine. Given the severity of some of the other charges, I would guess, well, there's not a common scheme or plan for murder. Okay, he's not been accused of that before, and the defense pointed out in one of its pretrial motions that this guy does not meet the Florida statutory definition of a sexual predator, yet he's been referred to under those terms before. Well, on the streets, what he's been accused of and convicted of in the past would fit that definition, but in order to be a sexual predator in Florida, there has to be violence attached to all of the predatory actions, okay, and apparently that hasn't stuck, at least in the defense's view. So, look, I mean, this case has spurred a lot of discussion, as well it should, about proper punishments, what properly should be thrown at offenders of this type, how long they should be incarcerated. You've got the legislature weighing in on it. Elected officials are commenting on this case, as well they should. But look, we still have to try the defendant fairly on this particular set of circumstances, and to not let it in, I think, look, we want to have convictions that are clean, as I say all the time. The defendant deserves a fair trial, absolutely, okay. The judge was clear that she was going to whittle out jurors who have a preconceived bias in this case, and look, a lot of people probably do because they've been listening to the social commentary. But look, I can sit here based on what I know and say, I think this guy ought to be convicted, but I'm going to feel a lot more comfortable if he's convicted fairly.
Absolutely. And I think that that's the reason. I think the only way that evidence gets in is if he testifies, and I don't think that that's going to happen, given the allegations against him.
Oh, he testifies, everything else comes in, as you know, and I don't think he's going to risk that.
Yeah, nor should he. Nor should he. I mean, he just had his little opportunity to show himself in front of the jury by saying don't cross-examine her, which I keep thinking might have been some strategy, but we'll never know for sure. But it is definitely one of those cases that you want him to have a fair trial so that there's no appellate issues here, and so that we can knock this case out with a conviction if that's the appropriate thing, which certainly it appears to be at this point in time. The judge, and you might know more about her, I know a little bit about her from reading about her in the articles, but she's followed this case since almost the beginning, and in fact, she's retired. But the presiding judge is allowing her to try this case because she knows the players so well, she knows the issues so well, she decided so many of the pretrial motions. Have you had the chance to get a read on her of where she stands in this case?
Other than that she wants to apply the law as fairly as possible. You know, she's given good consideration of the motions that have been thrown in her direction. But as I understand it, she's the second judge to have had this matter. The first judge recused out. And I don't know the reason for that. I didn't dig that far into it, but I saw a recusal document in the file, so I don't know how that came to be. I know that this issue with this other inmate having information about this defendant, now that led to a whole mess of recusals because there are two inmates in neighboring cells. Okay, and one of them starts trying to snitch on the other one. We've seen this pattern before. Well, both are represented by the public defender's office, and then you have a conflict within the public defender's office. So the public defender had to conflict out. They had to hire private attorneys. The new attorneys for this defendant started throwing a fit about the procedure because somebody from the prosecutor's office planted a recording device in between the jail cells. The judge turned around and said, no, that's not an issue. We're going to allow this in, and we saw hints of it in the opening statements. You know, this use of the jailhouse snitches does bother me in a lot of ways because of the way that it kind of gets in through the back door, what the police couldn't get in through the front door through a direct interrogation. So that was one of the issues that I think was perhaps the most sticky one coming into the case. And
I think that's a good point, and it could be an appellate issue. I want to, in just a minute, throw to the first clip that we have of the mother, Rain Periwinkle. There's been a lot of, I mean, we've talked about it just right now, there's been a lot of blame laid on Rain Periwinkle. And do you think that it was smart, given her status and the expectation by the prosecution that she was going to be cross-examined pretty hard? Do you think it was smart to call her as their first witness?
I think it was. I mean, look, you want to start strong and end strong. She was there at the inception of this to set up the types of interactions that she, her family, and her daughter had with the defendant. Without her testimony, we wouldn't understand exactly how this went down. And look, people can come down hard on her, and she has herself admitted that alarm bells in many ways were going off, but as we understand it, she was in dire straits financially and thought that any financial help might at least be some sort of a godsend.
Right, and as you listen to her testify, you want to at least note that when we watch that video, she is shopping for her children. It's not like she's using this money that is being offered to her by Donald Smith to shop for herself. What we're going to do now is throw to a clip of her testimony so that those of you who missed it can get a sense of her. We do want to let you know that we're getting some word that when we come back to live in the courtroom, some of the testimony that you're hearing may be graphic. So for those of you with little ones in the room, you might want to put on some earphones or turn it off. For those of you who think that it might be too bothersome for you, it's understandable. We just wanted to let you be aware. When you come back, you'll have Aaron here as your host. I am done for the day and signing off, but thank you very much. And for this right now, the clip of Rain Periwinkle testifying.
Are you the mother of Cherish Periwinkle?
Yes,
Ma'am, how old was Cherish on June 21st of 2013?
8 years old.
And where were you and Cherish living at that time?
Allen Avenue.
Excuse me, ma'am, if you could try to repeat that answer because there's a little noise back here.
I have some.
Where were you living back on June 21st of 2013?
Allen Avenue.
Is that here in Jacksonville, Duval County, Florida?
Yes.
Who else was living with you and Cherish at that home?
My ex-boyfriend, Aaron Peterson. My daughter's Destiny and Nevaeh.
How old was Destiny at that time?
5.
And Nevaeh?
4.
On the evening of June 21st, 2013, were you preparing for Cherish to go on a trip the next day?
Yes.
Where was she going?
California to see her birth father.
And did she have plans and tickets to fly out to California early the next morning?
Yes.
At some point that evening, did you decide to go buy some things for her and for the household?
Yes.
Did your boyfriend Aaron go with you that night?
No.
Did he provide you with some money to spend so that you could go to the store and buy some things?
Yes.
How much money did he give you?
A $100 bill.
And was that $100 for buying everything at the store, or was that also for another purpose?
Yes. Another purpose.
What was that other purpose?
To take Cherish to the airport the next day in a taxi.
So in addition to buying items with a $100 bill, you had to have enough left over to go to the airport with a taxi and back?
Yes.
Did you drive at that time?
No.
Did you even have a car?
No.
So at some point, did you and the children walk to the stores nearby on Edgewood Avenue?
Yes.
How did you walk to the store? Did you have a stroller with you?
Yes.
And approximately how long did you and the 3 children take to walk from your house to the Family Dollar on Edgewood?
About 20 minutes.
Once you were at the Family Dollar, did you shop around and look for some items?
Yes.
Did you actually make some purchases?
Yes.
And were your children with you inside the Family Dollar?
Yes.
Once you made your purchases at the Family Dollar, did you walk across the street to the Dollar General, which was directly across Edgewood Avenue?
Yes.
And again, just walked with your kids in the stroller back over to that store?
Yes.
When you entered the Dollar General, what were you looking to buy at that time?
The pencil sharpener.
And were you also looking potentially at clothing and things of that nature?
Yes.
What had you bought previously over at the Family Dollar?
Just some household items. Trash bags. Some headbands for my children.
And once you walked across the street to the Dollar General, how long were you inside the Dollar General shopping?
Maybe an hour.
were you looking specifically at any item